The current state of law related to AI-created art is still evolving, and there is no uniform approach or clear legal framework established at the international level. Copyright law, which protects original works of authorship, applies to AI-created art just as it does to any other type of creative work. However, questions have arisen about who owns the copyright in AI-generated works and whether AI systems can be considered authors. In the United States, the Copyright Office has stated that copyright protection may be available for works created by artificial intelligence, but only if there is human involvement in the creative process. In the European Union, the European Commission has suggested that the person or organization that provides the AI system with the inputs and determines its objectives should be considered the producer of the work, and thus the copyright owner. There have also been debates around the use of AI in the creation of derivative works, such as using an AI system to generate new music or art based on existing works. In some cases, this may be considered transformative enough to be protected under fair use or fair dealing laws, while in others it may be seen as infringing on the original copyright holder's rights. Overall, the legal landscape regarding AI-created art is complex and still developing, with many unanswered questions and no clear consensus on how to address the unique challenges presented by these works. The question of whether artists who provide training data to an AI should be compensated is a complex and debated issue, and there is no clear consensus on the matter. On the one hand, it can be argued that artists who provide training data are contributing to the development of the AI system and should be compensated for their work, just as they would be compensated for any other type of creative work. In some cases, artists may be providing valuable data that helps to train the AI system and make it more effective, which could be seen as deserving of compensation. On the other hand, it can be argued that the use of training data is a common practice in the development of AI systems, and that artists who provide this data are often doing so voluntarily, without any expectation of compensation. Furthermore, the use of training data may not necessarily involve the creation of original works of authorship, which are typically protected by copyright law. Ultimately, whether artists providing training data to an AI should be compensated will depend on a variety of factors, including the nature of the data being provided, the terms of any agreements between the artist and the AI developer, and the prevailing legal and ethical norms in the relevant jurisdiction. As AI continues to develop and evolve, it is likely that the question of compensation for training data will remain an important and debated issue in the art and technology communities. As an AI language model, I cannot make predictions about how the law will evolve or how courts will interpret and apply it in the future. However, it is important to note that the law is not necessarily a zero-sum game between the rights of artists and AI companies. Rather, the law seeks to balance competing interests and provide fair and equitable outcomes that take into account the needs and perspectives of all stakeholders involved. In the case of AI-created art, this may involve developing legal frameworks that recognize both the contributions of artists and the unique capabilities and limitations of AI systems. This could include clarifying issues related to copyright ownership, compensation for training data, and the use of AI in the creation of derivative works. Ultimately, the development of legal frameworks for AI-created art will require input and collaboration from a wide range of stakeholders, including artists, AI companies, legal experts, policymakers, and the general public. By working together to address the complex legal and ethical issues involved, we can ensure that the rights and interests of all parties are protected in a fair and equitable manner. Yes, if you create an original image with the assistance of an AI, you can typically copyright it, just as you would with any other type of creative work. Copyright law protects original works of authorship fixed in a tangible medium of expression, including visual art, such as photographs, drawings, and paintings. The fact that an AI was involved in the creation of the image does not necessarily preclude you from owning the copyright in the resulting work. However, it is important to note that the specific circumstances of the image's creation can impact the copyrightability of the work. For example, if the image was created using pre-existing materials or data sets that were subject to copyright or other intellectual property protections, you may need to obtain permission or a license from the original rights holders before you can claim copyright in the resulting work. Additionally, if the image was created as part of your employment or under a work-for-hire agreement, the copyright ownership may belong to your employer or client rather than to you as the creator. Overall, the question of whether an AI-generated image can be copyrighted is a complex one that may depend on a variety of factors, including the nature of the data and materials used in the creation of the work and the specific legal and regulatory frameworks in the relevant jurisdiction. It is always advisable to consult with a legal expert to determine the specific copyright implications of a given AI-generated image. The question of whether you would own the legal rights to a new song created by an AI that was trained on music from the Beatles is a complex one, and the answer would depend on a number of factors, including the specific legal and regulatory frameworks in the relevant jurisdiction and the nature of the AI-generated work. In general, copyright law protects original works of authorship, including musical compositions, lyrics, and sound recordings. If the AI-generated song is deemed to be an original work that is not substantially similar to any pre-existing works, then you may be able to claim copyright ownership over the composition and lyrics of the new song, as well as any sound recordings that are created of the song. However, if the AI-generated song is found to be substantially similar to existing works, such as songs by the Beatles, then you may be at risk of infringing on the copyright of those existing works. The use of pre-existing works as training data for an AI may also raise questions about fair use or fair dealing, depending on the specific circumstances of the use. Overall, the question of ownership and copyright of an AI-generated song trained on music from the Beatles is a complex one that may depend on a variety of factors. It is advisable to consult with a legal expert who is familiar with copyright law in your jurisdiction to determine the specific legal implications of creating such a work. The legal complexities of ownership and copyright for AI-generated songs trained on music by the Beatles can be quite significant, and there are a number of issues that would need to be carefully considered. One of the key issues is whether the AI-generated song is deemed to be an original work that is not substantially similar to any pre-existing works, such as songs by the Beatles. If the AI-generated song is found to be sufficiently original and distinct, then the person who created the song may be able to claim copyright ownership over the composition and lyrics of the new song, as well as any sound recordings that are created of the song. However, if the AI-generated song is found to be substantially similar to existing works by the Beatles, then the person who created the song may be at risk of infringing on the copyright of those existing works. In this case, the use of pre-existing works as training data for an AI may also raise questions about fair use or fair dealing, depending on the specific circumstances of the use. Another issue is the question of who owns the copyright in the training data used to create the AI-generated song. If the training data includes pre-existing works that are subject to copyright, such as songs by the Beatles, then the original rights holders may have a claim to ownership of the training data. This could potentially impact the ownership and copyright of the AI-generated song as well. Overall, the legal complexities of ownership and copyright for AI-generated songs trained on music by the Beatles are significant, and it is important to consult with a legal expert who is familiar with copyright law in your jurisdiction to determine the specific legal implications of creating such a work. Yes, there can be differences in legal ownership and copyright between AI-generated images and AI-generated music, as these are different types of creative works that are subject to different legal frameworks. In general, copyright law protects original works of authorship fixed in a tangible medium of expression, including visual art such as photographs, drawings, and paintings, as well as musical compositions, lyrics, and sound recordings. The fact that an AI was involved in the creation of the work does not necessarily preclude copyright ownership by the person who created or commissioned the AI-generated work. However, there are some differences in how copyright law is applied to different types of works. For example, the legal protections afforded to musical compositions and sound recordings may differ from those afforded to visual art, and the specific requirements for copyright registration and enforcement may also differ depending on the type of work. Additionally, the question of ownership and copyright may be further complicated by factors such as the use of pre-existing materials or data sets in the creation of the work, as well as the specific legal and regulatory frameworks in the relevant jurisdiction. Overall, while there may be some differences in legal ownership and copyright between AI-generated images and AI-generated music, both types of works are subject to copyright law and may require careful consideration of the specific legal and regulatory frameworks in order to determine ownership and copyright status. From a logical perspective, the question of whether a person who prompts an AI to create an image or song should have ownership of the new work is a matter of debate and may depend on a variety of factors. On one hand, it could be argued that the person who prompts the AI to create the work should have ownership, as they are providing the creative direction and input that guides the AI's output. Additionally, the person may have invested resources, such as time and money, into the development of the AI system and the creation of the work, which could be seen as a basis for ownership. On the other hand, it could be argued that the AI itself is responsible for the creation of the work, and that the person who prompts the AI is merely providing a prompt or a set of instructions. In this view, ownership of the work may belong to the AI or to no one at all. Ultimately, the question of ownership of an AI-generated work is a complex one that may depend on a variety of factors, including the specific legal and regulatory frameworks in the relevant jurisdiction. It is important to consult with legal experts who are familiar with copyright law in your jurisdiction to determine the specific legal implications of creating such a work.